How would you feel if you told your employer an idea to save your company money, but your employer rejected it, only for the company to implement a similar idea over a year later? Would you feel like your company owed you something, especially if it had promised a cash reward for ideas that saved it money? This is what happened in Schott versus Westinghouse Electric Corporation, in a case involving the doctrine of unjust enrichment. Westinghouse Electric Corporation had a formal suggestion program in which Westinghouse would give employees cash rewards for providing suggestions that increased productivity or saved it money if it adopted the suggestion. Rewards ranged from $5 to $15,000. Rejected suggestions could be reopened within 1 year or resubmitted after 1 year, and applicants agreed to be bound by the suggestion committee's decisions. Harry Schott worked at Westinghouse and submitted an idea to manufacture circuit breaker panels with heavy-gauge steel rather than cast aluminum to save money. Westinghouse rejected the idea, explaining that the cost to redesign the breaker panels would outweigh the savings. However, Westinghouse informed Schott that if it redesigned the panels in the future, it would reconsider his idea. A year later, Schott resubmitted his idea and was again rejected. Westinghouse reiterated the same reasons it did in its first rejection, but also mentioned that it was already working on an independent redesign of the panels. Westinghouse later redesigned its panels in a manner similar to what Schott had suggested. Schott initially sued Westinghouse for breach of contract in the Court of Common Pleas, Allegheny County. The trial court found that no contract had been created because Westinghouse had rejected Schott's idea. Schott amended his complaint to include a cause of action under a contract theory and for unjust enrichment. The trial court found that no substantial allegation was added to the original complaint and so dismissed the amended complaint. Schott appealed to the Pennsylvania Supreme Court.